San Francisco Bay Area criminal defense attorney Joseph Tully, and from Houston, Texas, criminal defense attorney and former prosecutor Nicole DeBoard, who's been with us throughout the morning. And Nicole, I've tried to ask you about 10 times this morning, but the judge always jumps back on the bench before I can get your opinion. Your take on the difficulty they're having finding jurors, at least this morning, and as Judge Cale pointed out, at one point, 8 of the last 11 had to be bounced for cause.
It's definitely an interesting morning in terms of all of the strikes for cause. And even more interesting, in my opinion, is that some of these have had to be peremptory strikes, because that last juror, for example, had quite a few things to say that indicated he had already formed a very strong opinion. And nevertheless, the defense had to burn a peremptory challenge, which was very surprising to me that they didn't at least seek to try for a motion for cause, strike for cause in that particular instance.
Yeah, Joseph Tully, I'm not sure if you watched all of that, but it did seem as though there was an opening there for, to Nicole's point, at least asking for this juror, because it was obvious this person was not going to be on the panel, but to ask for him to be dismissed for cause. Your take?
I agree with Nicole. A motion for a peremptory motion or a motion for cause should have been given. The juror said that essentially that he could not be fair, that he had formed an opinion already leaning towards the prosecution. And in that instance, you don't ask the juror to say, so you believe that you could be unfair, right? You leave it as it is, and then you argue to the judge that the record establishes that the juror had a bias.
Well, 69, I think it was obvious the defense did not want this individual on the panel because of his bias. 67 was a different story. This was an executive director of a youth ministry. He didn't seem to know a ton about the case, and what he did know was inaccurate, but the way he described what he knew was interesting. He said that Chauvin was detaining Mr. Floyd, who was under the influence, and he passed away. At the end of the day, the defense used a strike. Nicole, you were along with us during this. Was that surprising to you that the defense struck this juror?
It was a little bit surprising to me. We have to keep in mind that we're not seeing everything that they're seeing in terms of the questionnaire. So there may have been answers that we just don't know are out there. But for what we heard actually in the courtroom, I was a little surprised that they wanted to strike this particular jurors. One of the most interesting questions, seems like such a minor one, that they have asked is, what do you think about all this fencing and security around the courthouse? And this particular juror answered that it made him feel much more secure. And I think the answer to such a simple question such as that one can tell you a lot about the frame of mind of the person who is sitting there on the stand answering the questions. And it is something that when they answer that they feel more secure because of the intense security might lean a little bit toward the defense favor, in my opinion.
Yeah, this is one of those jurors I wish I could have seen. Most of them you can kind of visualize what's on the, but this one was interesting because he's obviously a very religious man. He says that he prayed for everybody involved. His family prayed for everybody, including Derek Chauvin. He's also a big skateboarder. And he talked about that in some interaction with the police, being a skateboarder. Take a listen.
So we showed up at a skate park, and the owner had hidden a key for us, and so we went in and we're skating in the park in the middle of the night, and police officers arrived and thought we had broke in, and were pretty forceful in their language and how they treated the situation because of their perspective. And we were like, it's okay, it's fine, we have a key. The owner let us in. And so it was kind of just a misunderstanding. But I do understand from their perspective, like, we were in the park and it's closed. So it makes sense.
Yeah, I'm not sure if this is a clean-cut Minnesota, blonde guy, or if he's, San Francisco like you, Joe, the long-haired skater type. This is the one I would love to have seen, just for my own curiosity. Joseph, when you look at a guy like this, and you look at the fact that he's a very religious person. He was very articulate. He just seemed to be not that bad. You only get 15 strikes. They're now 2-11. Are they getting into the danger territory of the defense?
Oh, I think so. There's definitely a game that's going on during voir dire where the other side tries to make their opponent run out of their peremptories. So if the defense gets to 15, the prosecution can go back. They have several left, and they can strike existing jurors that have been already accepted, and the defense can't do anything about it. If a really bad juror comes up, the defense can't do anything. So the defense needs to be very, very cautious and selective in using their peremptories.
Now, I don't believe they can retroactively strike in this courtroom and under these rules, but the defense does have that option if they have cause to go back and strike existing already pictures. But to your point, they absolutely can pluck away to get to, because they know where this is going. Everybody's got the, their lineup, it's sequential. They know that juror 75 might be a doozy, and if they don't have a strike, they'll just pluck to get to that person, get them on to the jury. How difficult is this process, Nicole, given not only the split-second decisions they have to make, the person's there, yes, you're going to bounce them or not, but then you add just the high-profile nature of this trial and the fact that all of these jurors have seen the number one piece of evidence in this case, that video.
Such a challenging case. And obviously with individual voir dire, as we can see, this is taking a very long time. This defense lawyer has done an incredible job of remaining on his game just diligently and asking thorough questions of each of the veneer members as they come forward for consideration. It's incredibly difficult. And, you have to be careful, too, as the lawyer, that you're asking questions that are thoughtful and that if someone does end up on the jury, you're not going to have already put them off. And as he gets closer to running out of those peremptory challenges, that becomes even more of a concern.
Yeah, Eric Nelson, I think by all accounts, has done a fantastic job. He, along with his assistant Amy Voss, they are a two-person team. Well, Derek Chauvin is also helping out, taking notes. But the prosecution has an army. They have the attorney general and the force of the government and a jury consultant on their side. So hats off to everybody. But I take your point. Eric Nelson really has been doing an excellent job so far. We're going to step aside, take a break. We'll have much more when we return. Stay with us. Welcome back to CourtTV Live. There is a lot of pressure on these prospective jurors. They have to consider the weight of holding another person's fate in their hands. But many have mentioned how their jury service could impact their own personal relationships. Several potential jurors disclosed they may have trouble explaining their verdict decision to friends and colleagues should they be selected to hear this case. Yesterday, juror number 60 went into detail about how much his friends on his college campus shape his own opinions.
One of the statements is, blacks and other minorities do not receive equal treatment as whites in the criminal justice system, and you strongly agreed with that. Can you explain what you were thinking or why you strongly agree with that statement?
I don't have any personal experience per se, but I think most of it is formed by just my surroundings. Given that I'm a student, I am surrounded by people of my age, and my demographic tend to be very liberal. And I have taken some sociology and anthropology classes where these things were discussed in such a way that would have formed these opinions. But it's not a belief that I have fostered myself, if that makes any sense. It's not because I have any sort of strong root reason to have that belief.
Yeah, that makes sense.
Yeah.
There is a statement that reads, Minneapolis police officers are more likely to respond with force when confronting black suspects than with dealing with white suspects, and you somewhat agreed with that. Why did you choose that?
The reason for the difference in answer, I'm less sure about the second one, is because the second one's way more specific. So because I don't know much about the actual statistics or have any experience with that, I'm less inclined to agree. whereas the first statement is sort of like, it's vague, it's general. That's why the answers are the way they are.
There was a statement that said, "I do not trust the police," and you somewhat agreed with that. Why would you somewhat agree with that?
For the same reason in the first question, I'm just surrounded by an atmosphere of distrust towards the police force, but it's not a belief that I foster myself, and it's not something that I will hold strongly to, simply because it's, do you get what I'm saying? Like, it's when you realize it's just the way it is, you just say it, but then you don't know if you actually believe in it.
Sure. Kind of finding your way on your own, right?
Yeah.
Well, let me ask you that. I mean, you kind of referenced being on campus and being surrounded by a certain viewpoint, and I'm not coming out and asking if you agree or disagree or any of that nature at this point. I guess my question is, we're doing our best to obviously maintain your anonymity during this jury selection process and throughout the course of the trial. But at some point, your name may be, I have no idea when, but it may be released to the public. If you were to be identified publicly, how would you take that back to your campus and have conversations with your fellow students about that?
What do you mean how I would take it?
Well, I mean, so there are two possible outcomes here, right? One is a guilty verdict and one is a not guilty verdict. And you've sort of kind of indicated that the people that you go to school with tend to have a more liberal bias or perspective, right? Mm-hmm. And let's assume, for the sake of this hypothetical, that the jury returned a not guilty verdict in this case. Would you first acknowledge that's a possibility?
Yes.
And now you're back on campus. You've been identified as a juror in this case who voted to find Mr. Chauvin not guilty. How would you engage that how would you have that conversation with your students? Would you be concerned about having that conversation?
I wouldn't be concerned. Suppose in this hypothetical situation, I guess the expectation of my peers would be to justify myself, right? Suppose I have liberal friends and they're like, well, why is it, right? Well, why didn't you, I would justify it in such a way that, like, you didn't know all the facts, right? Like, there wasn't, like, actual facts presented at the case. And regardless of the political agenda of what you might have or might anyone have, it's the facts that sort of ultimately count. So.
Fascinating. At the end of the day, he was not selected. In fact, the defense used a peremptory strike to not allow this student to be on the jury. Still with us from San Francisco, criminal defense attorney Joseph Tully, and from Houston, Texas, criminal defense attorney and former prosecutor Nicole DeBoard. The amount of young people on this jury panel, first of all, the prospective jurors, is just way out of whack from a normal trial. And a big part of that is COVID, because if you're of a certain age, you can just check the box and you're not expected to serve. And one of the older gentlemen that did come in said, I had an opportunity to obviously opt out, but I wanted to be here and do my civic duty. But we have not seen the parade of elderly that we normally see in a criminal case who are excited for jury duty. How does that affect things, Joseph? A younger jury, I would think, is very pro-prosecution, which is, of course, reverse of a normal criminal case. But in this case, they want the young person.
The prosecution normally speaking, will want a younger person here. As you indicated, normally prosecutors kick off younger jurors because they tend to be, the belief by prosecutors is that younger jurors are more wishy-washy and they won't have their own opinion and they'll go along with sort of the herd. In this case, the prosecution is going to seek younger jurors because they tend to be more liberal and more in tune with the anti-police sentimentalities that are sort of going around now as a result of this case.
Nicole, is this another in what is now becoming a fairly long list of things that might come up on appeal if Chauvin's found guilty?
Absolutely. And, for people picking juries across the country right now while COVID is still ongoing. The questions about whether or not the people responding to these calls for jury service are a fair cross-section of the community are being raised and answered differently in different courtrooms all over the country. And, we can certainly see the result here. Your point is certainly well taken that we are seeing a much younger group of people show up to answer questions before the court, while some who might have been great jurors are completely absent. So it's a concern.
Joseph, do you think this announcement of the $27 million financial settlement with the Floyd family, which was headlines across the country, but specifically in Minneapolis, is an issue?
Oh, definitely. It's number one, it's more news. There's more talk about the case going out. It's another thing where the Mr. Chauvin's employer, the city, is capitulating. Hey, we're going to pay out money to the victim here. And so it's a sense that their case isn't strong, that they were in the wrong, and that the officer was in the wrong. So I think that it's not good for the defense in this case, for sure.
All right, Joseph Tully, Nicole DeBoard, thank you for your expertise and your time on this Tuesday. We appreciate it. We're going to step aside and take a break. When we come back, it's time for the Daily Sidebar.